The Supreme Court did something this morning that may make some of your heads explode. Now, you guys know I'm constantly trying to draw your attention to examples where the Supreme Court does not act like a bunch of partisan hacks, right? And last week they gave me a pretty good example, 6 unanimous opinions. But this week they outdid themselves, because we just got a concurring opinion from one of the most liberal and conservative justices on the court. And if that doesn't demonstrate bipartisanship, dissent might have proved my point better, but I'll take this. Okay, so we are going to talk about Parrish v. United States, which was released this morning, June 12th, 2025. It's probably not a huge surprise that this is a procedural case. We see the ideological splits in ideological cases, right? But they can show up in procedural cases plenty as well. The other kind of cool thing is that the concurrence here, which by the way I don't think I said, is between Jackson and Thomas, is actually pretty practical and kind of sweet, and gives us kind of a cool example of what might eventually become a circuit split. So I'll show you that too. I'm Bryan, by the way. I make videos about civics and law. If you would like to read this case, it is in my link tree in my shared documents, which is probably at the bottom of the screen right now. Please comment your thoughts on this case and comment anything else you feel like saying. Please repost, share, like, and get this video out there so people will see it. This is information in real time about how our courts work, and it's important for us to understand. Okay, now I'm going to run through the facts as quickly as I can. The entire question of this case is about dates. So I made a timeline. Ta-da! And I don't have the name in front of me, but thank you to whomever sent me this whiteboard off my Amazon wish list so that I can make cool little timelines for my videos. Okay, real fast. Mr. Parrish was in a federal prison and he sued in federal court. On March 23rd of 2020, his case was dismissed. On March 24th of 2020, he was transferred from a federal prison into a state penitentiary, and no one told the court. Now, I didn't put it on here, but somewhere around April 6th, notice of his dismissal arrived at the federal prison where he no longer was housed. Now, the rules say that in a case like this, if you want to appeal the dismissal, you have to provide notice of that appeal within 60 days. That date, taking weekends and holidays into account, would have been May 25th. Now, there was also an option to request an extension, but that was due June 25th. Mr. Parrish also received notice of his dismissal right around June 25th. That's basically how much time it took to get forwarded from the federal prison to the state penitentiary. So he doesn't get notice of the dismissal until June 25th, the day that even the extension passes. So on July 9th, he mails a handwritten notice of appeal explaining what had happened to the court, and it is received by the court on July 13th. So that's kind of our primary timeline. In short, he wants to appeal. He never got the notice of dismissal because his address was changed beyond his control. It's not like he had an option of where he was living. And so as soon as he got notice, he filed a notice of appeal. This goes through a court process and they agree, yeah, he should probably get another chance to file a notice of appeal. So the court decides to reopen the notice of appeal period from January 8th to January 22nd. Mr. Parrish submits a brief on January 27th, 5 days after this second period closes. The question before the Supreme Court is, was this the notice, or did he have to submit a second notice down here? In which case, this was the notice and it was late. Now, almost everybody in the court agrees. This was the notice, he did not have to submit a second one. Gorsuch disagrees, I'm not going to go into that. But the concurring opinion from Ketanji, Jackson, and Justice Thomas has a different reason for agreeing, and I'm going to get to that in a second. But I think it's pretty cool that Thomas and Jackson are agreeing on a separate opinion, even if it's something procedural like this. I think it provides good evidence that the court is not partisan on every single issue, and behind the scenes, they probably get along just fine. So first I want to explain the majority's reasoning. The short summary is they didn't feel that submitting something early was the same as submitting something late. Submitting something early felt like a technical violation, while submitting something late felt like something different. And they talked a lot about merit versus technical reasons for denying a claim. If you're going to deny a claim, it should be based on the merits rather than some technicality. Now, I don't feel like they ever closed the loop on explaining why something coming in late was technical versus meritorious. I think I get it, and they didn't have to explain it, but I wish they had. Neither here nor there. But what they did say is that submitting, for example, an incomplete filing late or submitting a complete filing early were both technical violations and should not be a reason that you dismiss the entire case. Whereas a bad case or a bad argument on its merits was a perfectly good reason to get rid of a case. But getting to that whole argument also rested on a rule of interpretation that I want to explain real quick because it is kind of important since we've talked about rules of interpretation in the past. The court says that when Congress legislates, when Congress writes a rule, and remember all these rules about when you have to turn things in were all written by Congress. When Congress legislates and doesn't specify otherwise, they said, they do so, and this is a complicated sentence, I'll break it down in a second, they do so against a background of common law adjudicatory principles. That means, unless they say otherwise, we presume that the regular rules of common law interpretation, the regular rules of common law adjudication apply, because we assume that Congress implied those as well. unless they say otherwise. And in this case, Congress had not said otherwise, so they use common law interpretation rules. Which means, for example, let's go back, see when this law was written, and see how we've interpreted it in the past. And they did. They looked at some old interpretations which talked about the purpose of pleading is to facilitate a proper decision on the merits. So this is all about figuring out the merit of an argument. Imperfections in notice of appeal should not be fatal. And most directly, the technical defect of prematurity should not be allowed to extinguish an otherwise proper appeal. So again, being too early is not a reason to dismiss a case. They also say the purpose of this whole thing is to give notice. It's not like the other side is magically forgotten. They were put on notice. They're still on notice. When Mr. Parrish sent in his notice, it stays on notice all the way through, and it doesn't have to be resubmitted later. And in the end, they ended up announcing that as an official rule. When a district court grants reopening to a litigant who has already filed notice making his intent to appeal clear, no second notice of appeal is required. Instead, the original notice relates forward to the date reopening is granted. So that is the new rule announced by the majority. So let's talk about the concurring opinion because I think it's kind of cool. So Jackson wrote it, Thomas signed on, and they said, yeah, we get it. They went into all this breakdown of common law and everything, but we really don't think any of that was necessary. Because in practice, in court, when somebody submits one of these things saying, excuse me, I missed the deadline because all this stuff happened and I need you guys to extend the deadline for me, they usually attach the thing they need to submit to the request for an extension. It's usually like stapled on. As a practical matter, they almost always include it. And it's true, whenever you request something special from the court, you usually attach the thing you want them to approve along with it. So there's really no reason to ask them to submit it again. That's ridiculous. And that's what Jackson and Thomas say. The rule should be just use the thing that's attached if it's there. And you guys have asked me before when concurring opinions might matter. And I'm willing to bet you that this is one of the examples where the concurring opinion will come up again. Because I'll bet you that some circuits are going to take that on as the rule. Because it's really practical, it makes a lot of sense, and it's not contrary to the rest of the opinion. You can accept both. I'm willing to bet that this becomes one of those circuit splits, where some circuits take on the concurring opinion and some don't. And 30 years from now, somebody might be suing the court because of some technical violation that's evolved from one of these circuit splits, and we may have to hear this whole thing again. The Supreme Court may have to come back to this and solve this circuit split because of something that's developed over time. This is how these things happen over time in common law. Scott, James, Christopher, and Evelyn, thank you very much for your support. There's a copy of this case and the other cases that were released today in the shared documents folder of my link tree, as well as other ways to support me if you want to. I can't do this without your support, so thank you guys very much. Please like, share, comment, and thanks for watching.